Negotiations ACT 1881. 3.1 Definition and Features of Negotiable Instrument. Introduction. The law relating to negotiable instruments is contained in the Negotiable Instruments Act 1981. It is an act to define and amend the law relating to promissory note, bills of exchange, and checks. The purpose of the Act is to present an orderly and authoritative statement of the leading rules of law relating to the negotiable instruments. The word negotiation has come from Latin word negos, which means business. Applicability of the Act. This Act is applicable to the whole of India. Negotiable instrument. Generally, an instrument, under legal parlance, denotes a piece of paper by which rights or liabilities of a person is created, satisfied, diminished, enhanced in relation to any other person. Section 13 of the Act defines the terms negotiable instrument as a promissory note, bill of exchange, or either payable either to order or to bearer. A promissory note, bill of exchange, or check times is payable to order, which is expressed to be so payable or which is expressed to be payable to a particular person and does not contain words prohibiting transfer or indicating an intention that it shall not be transferable. Times is payable to the bearer, which is expressed to so payable or on which the only or last endorsement is an endorsement in blank. Times either originally or by endorsement is expressed to be payable to two or more payees jointly, or it may be made payable in the alternative to one of two, or one or some of several payees. Section 13 shows that the Act is confined to three specific types of instruments most in common use, namely, promissory notes, bills of exchange, and checks. The Contract Act is a general statute dealing with contracts. The Negotiable Instruments Act is a statute dealing with a particular form of the contract. The law laid down for special cases must always overrule the provisions of general character, as held in Quong Hip Loan Saw Mill Co. v. CAML Firms, AIR 1933 Rank. 131. The following are not the negotiable instruments. Times share certificate passing from hand to hand with blank transfers. Hajarimall v. Status Chandra, ILR 46 Call. 331. Times deposit receipts. Anantaram v. OL of TNQ Bank, 1939 Mad WN 1096. Times mates receipt. Nacheppa Chette v. Eravadi Flotilla and Co. ILR 41 calories. 670. Times bill of lading. United Bank of India v. NS Bank, AIR 1959 calories. 328. Times promissory note Khirodnath Gaunshya v. Arjun Pen, 1971, to cut. WR to 23 times a benefit under a letter of credit. Joseph Pike and Son v. Kedarnath, AIR 1960 to Call. 326. Essential features of a negotiable instrument. 1. It must be in writing. 2. It should be signed by the maker or drawer. 3. There must be a promise or order to pay. 4. The promise or order must be unconditional. 5. It must call for payment in money, and money only. 6. It should call for payment of a certain sum. 7. The property in the instrument may be passed in two ways: A. By mere delivery, and B. By endorsement and delivery. 8. The consideration is also presumed to have been passed. Promissory Note Section 4 of the Act defines the term promissory note as an instrument in writing, not being a bank note or a currency note, containing an unconditional undertaking, signed by the maker, to pay a certain sum of money only to, or to the order of, a certain person, or to the bearer of the instrument. Example 1. I promise to be or order 50,000 2. I acknowledge myself to be indebted to be in 1 lakh to be paid on demand for value received. The instruments in the above two examples are promissory notes. 3. I promise to pay B 20,007 days after my marriage with Helen. 4. I promise to pay 50,000 on DS death, provided D leaves me enough to pay that sum. The instruments in the above two examples do not amount to promissory notes. The High Court in Sansing v. Madandas Panikaya 1976 MP 144 held that an instrument is a promissory note if there are present the following elements times there should be an unconditional undertaking to pay, times the sum should be a sum of money, and should be certain, times the payment should be the order of a person who is certain, or to the bearer of the instrument, times the maker should sign it. The High Court, Andhra Pradesh in Bahadurinisa v. Vasudev AIR 1967 AP 123 categorized the promissory note into three types times a promise to pay a certain sum of money to a certain person, times a promise to pay a certain sum of money to the order of a certain person, times a promise to pay the bearer. Though currency note has all the features of promissory, it is not to be considered as such. Further, bearer promissory note cannot be issued, as it would have the same feature of a currency note. Bill of Exchange. Section 5 defines the expression Bill of Exchange as an instrument in writing containing an unconditional order, signed by the maker, directing a certain person to pay a certain sum of money only to, or to the order of, a certain person or to the bearer of the instrument. A promise or order to pay is not conditional within the meaning of this section and Section 4, by reason of the time for payment of the amount or any installment thereof being expressed to be on the lapse of a certain period after the occurrence of a specified event which, according to the ordinary expectation of mankind, is certain to happen, although the time of its happening may be uncertain. The sum payable may be certain within the meaning of this section and Section 4, although it includes future interest or is payable at an indicated rate of exchange, or is according to the course of exchange, and although the instrument provides that, on default of payment of an installment, the balance unpaid shall become due. The person to whom it is clear that the direction is given or that payment is to be made may be a certain person within the meaning of this section and Section 4, although he is misnamed or designated by description only. The Calcutta High Court in Hundi v. Sinha v. Bidya Bhashan AIR 1955 calories. 562 narrated the essential character of a bill of exchange, which is that it contains an order to accept or to pay, and that the acceptor should accept it. In the absence of such a direction to pay, the document will not be a bill of exchange or a hundi. The following are the bills of exchange. Times a banker's draft. Birbhum Central Co-op Bank v. Pioneer Bank Limited. AIR 1956 calories. 615. Times a demand draft even if it be drawn upon another office of the same bank. SN Shukla v. Punjab National Bank Limited. AIR 1960 all. 238. Times an order issued by a district board engineer on government treasury for payment to or order of a certain person. Rangaswamy v. Sankalingam. ILR 43 MAD 816. Check. The term check is defined under Section 6 of the Act. It is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand, and it includes the electronic image of a truncated check and a check in the electronic form. For the purposes of this section, the terms a check in the electronic form, truncated check are defined, which has been substituted by the Negotiable Instruments Amendment Act 2015, with effect from 26 December 2015. A check in the electronic form is a check drawn in electronic form by using any computer resource and signed in a secure system with digital signature, with or without biometric signature, and asymmetric crypto system or with electronic signature, as the case may be. A truncated check is a check which is truncated during the course of a clearing cycle, either by the clearing house or by the bank, whether paying or receiving payment, immediately on generation of an electronic image for transmission, substituting the further physical movement of the check in writing. The expression clearinghouse is the clearinghouse managed by the RBI or a clearinghouse recognized as such by RBI. Distinction between promissory note and bill of exchange. Promissory note bill of exchange 1. It is defined in section 4 of NE Act 1881. 1. It is defined in section 5 of the NE Act 1881. 2. There are two parties, times maker, times pay. If it is given a guarantee, then there will be a third person, who is called as guarantor or surety. 2. There are three parties, times drawer, times drawee, times pay. 3. It contains a promise to pay. 3. It contains an order to pay. 4. No conditions shall be made in a promissory note. 4. A bill may be accepted conditionally. 5. The liability of a maker of the promissory note is primary and absolute. 5. The liability of the drawee of a bill of exchange is secondary and conditional. Distinction between promissory note and check. Promissory note check 1. It is defined in section 4 of NE Act 1881. 1. It is defined in section 6 of the NE Act 1881. 2. There are two parties, times maker, times pay. If it is given a guarantee, then there will be a third person, who is called as guarantor or surety. 2. There are three parties, times drawer, times drawee, times pay. 3. Promissory note contains a promise to pay the sum with interest or without interest at a later date. 3. A check is payable immediately on demand without any days of grace. 4. Promissory note is not crossed. 4. Check can be crossed. 5. No protection is available to the payoff note. 5. Statutory protection is given to the drawee banker. Section 128, 6. A promissory note cannot be self-drawn. 6. A check can be self-drawn or bearer check. 7. No criminal liability shall be imposed on the maker. 7. Criminal liability may be imposed on drawee for the dishonor of checks in certain circumstances. 8. Stamp is necessary. 8. Stamp is not necessary. 9. Limitation 3 years. 9. Limitation 6 months. Distinction between bill of exchange and check. Bill of exchange check 1. It is defined in section 5 of NE Act 1881. 1. It is defined in section 6 of the NE Act 1881. 2. There are three parties, times drawer, times drawee, times pay. 2. There are three parties, times drawer, times drawee, times pay. 3. Bills of exchange are not crossed. 3. Checks may be crossed. 4. Generally 3 days of grace are given for the payment in case of a bill of exchange. However, This convenience is not allowed in case of bill of exchange payable on demand. 4. Immediate payment is required in case of check. No grace days are allowed. 5. Anybody including banker may be a drawee in case of bill of exchange. 5. The drawee is always a baker. 6. It must be accepted before the acceptor can be made liable upon it. 6. It requires immediate payment. It does not require acceptance of the maker. Thus, the question of acceptance does not arise in case of check. 7. Where a bill of exchange is not paid and not honored, a notice of dishonor should be sent to the drawer to charge him. 7. Where a check is dishonored, notice of dishonor is not strictly necessary. The banker can return the check with the memo referred to drawer, which is a sufficient notice. 8. Statutory protection is not available. 8. Section 85 of the N.I. Act, 1881 affords protection to bankers. 9. Civil liability in case of dishonor of bill of exchange. 9. Criminal liability in case of dishonor of a check, bouncing of a check, and is liable to be prosecuted under Section 138 of the N.I. Act, 1881. Parties to the instruments. The transaction of the instrument requires at least two persons. One is the drawer and other is the drawee. The drawer of the instrument is the person who makes a bill of exchange or a check, and the person thereby directed to pay is called the drawee. In Shivant v. December AIR 1935 Law 153, it was held that the definition of drawer is not exhaustive. The maker of the promissory note can also be called a drawer. Drawer in case of need. When in the bill or in any endorsement thereof the name of any person is given in addition to the drawee to be resorted to in case of need, such a person is called a drawee in case of need. Acceptor. After the drawee of a bill has signed his assent upon the bill, or, if there are more parts thereof than one, upon one such parts, and delivered the same, or given notice of such signing to the holder or to some person on his behalf, he is called the acceptor. Acceptor for honor when a bill of exchange has been noted or protested for non-acceptance or for better security, and any person accepts it supra protest for honor of the drawer or any one of the endorsers, such person is called an acceptor for honor. Pay. The person named in the instrument, to whom or to whose order the money is by the instrument directed to be paid, is called the pay. Holder. Section 8 defines the term holder. The holder of a promissory note or a bill of exchange or check is any person entitled in his own name to the possession thereof and to receive or recover the amount due thereon from the parties thereto. Where the note, bill or check is lost or destroyed, its holder is the person so entitled at the time of such loss or destruction. In Anjaneyar v. Nagappa, AIR 1967 AP 61, it was held that the term holder as defined in Section 8 of the Act would not include a person who, though in possession of the instrument, had no right to recover the amount due from the parties thereto, such as the finder of a lost instrument payable to bearer or a thief in possession of such an instrument, or even the pay himself, he is prohibited by an order of court from receiving the amount due on the instrument. Where a plaintiff sued not as a holder in possession of the promissory note, but claimed to recover the debt on the basis of a succession certificate, he would be the only person entitled to recover the debt. Holder in due course. Section 9 defines the term holder in due course. It means any person who for consideration became the possessor of a promissory note, bill of exchange or check if payable to bearer, or the pay or the endorsee thereof, if payable to order, before the amount mentioned in it became payable, and without having sufficient cause to believe that any defect existed in the title of the person from whom he derived his title. In Braja Kishore Dikshit v. Purna Chandra Pend, AIR 1957 Ori 153, the High Court held that the holder in due course under Section 9 has to satisfy the following three conditions. Times an endorsee becomes a holder in due course for consideration. Times he can become an endorsee before the amount mentioned in the promissory note became payable, and times he should have no sufficient cause to believe that any defect existed in the title of the person from whom he was to derive his title. As regard to the second condition, the promissory note becomes payable either on demand or at maturity. Difference between holder and holder in due course. Holder in due course. 1. Holder is entitled in his own name to possess the instrument and the amount thereon from parties involved. 1. Holder in due course possesses the instrument for consideration before maturity and in good faith. 2. Title of the holder is subject to title of the transferor. 2. Holder in due course gets a better title than transferor. 3. Holder may receive the instrument without consideration. 3. Holder in due course always receives the instrument for consideration. 4. Holder does not get certain privileges available to the holder in due course. 4. Holder in due course always gets privileges not available to holder. Payment in due course. Section 10 defines this expression as payment in accordance with the apparent tenor of the instrument in good faith and without negligence to any person in possession thereof under circumstances which do not afford a reasonable ground for believing he is not entitled to receive payment of the amount therein mentioned. Example: where a bank makes payment in accordance with the apparent tenor of the instrument in good faith and without negligence under circumstances which do not afford a reasonable ground for believing that he is not entitled to receive payment, payment is said to be done in due course. Therefore, it is said a banker's duty in paying a check is discharged by payment in due course. Instruments. There are various types of instruments mentioned in this Act as follows. Times inland instrument, a promissory note, bill of exchange or check drawn or made in India and made payable in or drawn upon any person resident in India shall be deemed to be an inland instrument. Times foreign instrument, a promissory note, bill of exchange or check not drawn, made or made payable in India shall be deemed to be a foreign instrument. Times ambiguous instrument, where an instrument may be construed either as a promissory note or bill of exchange, the holder may, at his election, treat it as either, and the instrument shall be thenceforward treated accordingly. Times instruments payable on demand, a promissory note or bill of exchange, in which no time for payment is specified, and a check, are payable on demand. Times inchoate stamped instruments, where one person signs and delivers to another a paper stamped in accordance with the law relating to negotiable instruments for the time being in force in India, and either wholly blank or having written thereon an incomplete negotiable instrument, he thereby gives prima facie authority to the holder thereof to make or complete, as the case may be, upon it a negotiable instrument, for any amount specified therein, and not exceeding the amount covered by the stamp. The person so signing shall be liable upon such instrument, in the capacity in which he signed the same, to any holder in due course for such amount provided that no person other than a holder in due course shall recover from the person delivering the instrument anything in excess of the amount intended by him to be paid thereunder. Maturity 22 to 25. Section 22 provides the date of the maturity of the instruments. The maturity of a promissory note or bill of exchange is the date at which falls due. If the promissory note or bill of exchange does not express to be payable on demand, at sight, or on presentment, the maturity for such cases is the third day on which it is expressed to be payable. In Hemadri v. Seshamma, 1930 MW in 1232 it was held that the term used in this section cannot apply to a promissory note payable on demand. Calculation of maturity date. Section 23 provides for calculating maturity of bill or note payable so many months after date or sight. In calculating the date at which a promissory note or bill of exchange made payable a stated number of months after date or after sight or after a certain event is at maturity. Times the period stated shall be held to terminate on the day of the month which corresponds with the day on which the instrument is dated, or times presented for acceptance or sight, or times noted for non-acceptance, or times or protested for non-acceptance, or times the event happens, or times where the instrument is a bill of exchange made payable a stated number of months after sight and has been accepted for honor with the day on which it was so accepted. If the month in which the period would terminate has no corresponding day, the period shall held to terminate on the last day of such month. Example 1. A negotiable instrument, dated 29th January 2015, is made payable at 1 month after date. The instrument is at maturity on the third day after the 28th February 2015, i.e., 3rd March 2015, 2. A negotiable instrument, dated 30th August 2015, is made payable 3 months after date. The instrument is at maturity on 3rd December 2015, 3. A promissory note or bill of exchange dated 31st August 2015 is made payable 3 months after date. The instrument is at maturity on the 3rd December 2015. Section 24 provides for exclusion of days in calculating the maturity date. In calculating the date at which a promissory note or bill of exchange made payable a certain number of days after date or after sight or after a certain event is at maturity, the day of the date, or of presentment for acceptance or sight, or of protect for non-acceptance, or on which the event happens, shall be excluded. If the maturity day is a public holiday, then which will be the maturity date? Section 25 provides that when the day on which a promissory note or bill of exchange is maturity is a public holiday, the instrument shall be deemed to be due on the next preceding business day. The public holiday includes Sundays and any other day declared by the central government by notification in the official gazette to be a public holiday. Example: the maturity date is 14th April 2016. That day was declared by the central government as a public holiday on the eve of Dr. Ambedkar's birthday. In this case, the maturity date is 13th April 2016. 3.2 Crossing, endorsement, and material alteration. Crossing of checks. Section 123 provides that where a check bears across its face an addition of the words "and company" or any abbreviation thereof between two parallel transverse lines, or of parallel transverse lines simply, either with or without the words "not negotiable," that addition shall be deemed a crossing, and the check shall be deemed to be crossed generally. Section 124 provides that where a check bears across its face an addition of the name of a banker, either with or without the words not negotiable, that addition shall be deemed a crossing, and the check shall be deemed to be crossed specially, and to be crossed to that banker. Section 125 provides that where a check is not crossed, the holder may cross it generally or specially. Times where a check is crossed generally, the holder may cross it specially. Times where a check is crossed generally or specially, the holder may add the word not negotiable. Times where a check is crossed specially, the banker to whom it is crossed may again cross it specially to another banker, his agent, for collection. Payment of check. The payment may be made in respect of the following cases. Times payment of check crossed generally. Times payment of check crossed specially. Times payment of check crossed specially more than once. Times payment in due course of crossed check. Times payment of crossed check out of due course. Section 126 provides that where a check is crossed generally, the banker, on whom it is drawn, shall not pay it otherwise than to a banker. Section 127 provides that where a check is crossed specially to more than one banker, except when crossed to an agent for the purpose of collect, the banker on whom it is drawing shall refuse payment thereof. Section 128 provides that where the banker on whom a cross check is drawn has paid the same in due course, the banker paying the check, and, in such case check has come to the hands of the pay, the drawer thereof, shall respectively entitled to the same rights and be placed in the same position in all respects, as they would respectively be entitled to and placed in it if the amount of the check had been paid to and received by the true owner thereof. Section 129 provides that any banker paying a check crossed generally otherwise than to a banker, or a check crossed specially otherwise than to the banker to whom the same is crossed, or his agent for collection, being a banker, shall be liable to the true owner of the check for any loss he may sustain owing to the check having been so paid. Check bearing not negotiable. Section 130 provides that a person taking a check crossed generally or specially, bearing in either case the words not negotiable, shall not have, and shall not be capable of giving, a better title to the check than which the person from whom he took it had. Non-liability of banker. Section 131 provides that a banker, who has in good faith and without negligence received payment for a customer of a check crossed generally or specially to himself, shall not, in case the title of the check proves defective, incur any liability to the true owner of the check by reason only of having received such payment. A banker receives payment of a crossed check for a customer within the meaning of this section, notwithstanding that he credits his customer's account with the amount of the check before receiving payment thereof. It shall be the duty of the banker, who receives payment based on an electronic image of a truncated check held with him, to verify the prima facie genuineness of the check to be truncated, and any fraud, forgery or tampering apparent on the face of the instrument that can be verified with due diligence and ordinary case. Endorsement. Meaning of endorsement. The term endorsement can also be pronunciated as endorsement. This term is said to have been derived from the Latin word endorsum, which means upon the back. In is equal to upon, dorsum is equal to back. The endorsement means signatures of the person, which are generally made at the back of the instrument, for the purpose of transfer of rights to another person. Section 15 of the Act provides that when the maker or holder of a negotiable instrument signs the same, otherwise than as such maker, for the purpose of negation on the back or face thereof or on a slip of paper annexed thereto, or so signs for the same purpose a stamped paper intended to be completed as negotiable instrument, he is said to endorse the same and is called the endorser. Therefore, endorsement means writing of a person's name, other than maker, on the face or back of an instrument or on a slip of paper attached thereto for the purpose of negotiation. The person signing the instrument is known as endorser, and the person in whose favor it is endorsed is known as endorsee. Essentials of a valid endorsement. It must be on the instrument itself or on a separate slip of paper, called a longe, attached thereto. 2. For the purpose of negotiation, it must be signed by the endorser. 3. The instrument may contain, in addition to the signature of the endorser, the name of the endorsee also. No particular form of words is necessary for endorsement. 4. Endorsement is complete when the instrument is delivered to the endorsee with the intention of passing the property in it to the endorsee. Delivery is to be made by the endorser himself or someone on behalf of him. Who may endorse a bill? The first endorsement of an instrument can be made by the payee only. However, subsequent endorsement can be made by any person who becomes the holder of the instrument. As per Section 15, endorsement cannot be made by the maker or holder of an instrument as maker. Thus, if a bill is drawn payable to the drawer's order, the first signature of the drawer as a drawer is not an endorsement, but if he signs the bill's second time for the purpose of negotiating it, the second signature would be an endorsement. It may be noted that as per Section 51, every sole maker, drawer, payee or endorsee or all of several joint makers, drawers, payees or endorsees of a negotiable instrument may endorse and negotiate it. Types of endorsement. The endorsement of a negotiable instrument can be blank, 2 full, 3 restrictive endorsement or 4 conditional endorsement. As per Section 16, 1. If the endorser signs his name only, the endorsement is said to be in blank, and if he adds a direction to pay the amount mentioned in the instrument to, or to the order of, a specified person, the endorsement is said to be in full, and the person so specified is called the endorsee of the instrument. Section 49 of the Act provides the mechanism of conversion of a blank endorsement into a full endorsement. As per Section 49, the holder of a negotiable instrument endorsed in blank may, without signing his own name, by writing above the endorser's signature a direction to pay to any other person as endorsee, convert the endorsement in full, and the holder does not thereby incur the responsibility of an endorser. Example: X is a holder of a bill which has been endorsed in blank by Y and delivered to him. If X writes over the signature of Y pay to Z or order, X is not liable as an endorser, but this operate as full endorsement by Y to Z. As per Section 55, if a negotiable instrument, after having been endorsed in blank, is endorsed in full, the amount of it cannot be claimed from the endorser in full, except by the person to whom it has been endorsed in full, or by one who derives title through such person. As per Section 54, subject to the provisions hereinafter, Section 55 contained crossed checks. A negotiable instrument endorsed in blank is payable to the bearer thereof, even although originally payable to order. Example: If A is a payee and holder of a negotiable instrument, he endorses it in blank and delivers it to B, who in turn endorses in full pay to C or order. C transfers it to D without any formal endorsement. In the instant D, as the bearer of the instrument, is entitled to payment or to sue drawer, acceptor or A who endorsed the bill in blank, but he cannot hold B or C liable. However, C can sue B as he received the bill in full endorsement from B. But if C makes a proper endorsement in favor of D and then delivers to him, D can claim payment from all the prior parties including A and B in addition to C. As per Section 50, endorsement of a negotiable instrument followed by delivery thereof has the effect of transferring the property in the instrument to the endorsee with a further right to negotiate the instrument. But the endorser may, by express words, restrict or exclude such rights, in which it will be called a restrictive endorsement. As per Section 50D of a negotiable instrument followed by delivery transfers to the endorsee the property therein with the right of further negotiation. But the endorsement may be express words, restrict or exclude such right, or may merely constitute the endorsee an agent to endorse the instrument, or to receive its contents for the endorser, or for some other specified person. The effect of restrictive endorsement is that the endorsee gets the right to full payment of the bill when due for payment and has right to sue any party to the bill, but he has no right to transfer this right to any other person unless he expressly authorized to do so. The negotiability of the instrument comes to an end, and the last endorsee is the person to sue upon. However, when the restrictive endorsement transfer the right of further endorsement or transfer all the subsequent endorsee get the bill with same right and liabilities as the fire's endorsee after the first restrictive endorsement. As per Section 40, if the holder of a negotiable instrument without consent of the endorsee destroys or impairs the endorser's remedy against a prior party, the endorser is discharged from liability as if the instrument had been paid at maturity. Quite possible the holder of a negotiable instrument lost the instrument before its date of maturity. In such cases, as per Section 45A of the Act, the holder has right to claim a duplicate copy of the lost bill subject to giving security to the drawer, if required, to indemnify him against all persons whatever in case the bill alleged to have been lost shall be found again. If the drawer on request as aforesaid refuses to give such duplicate bill, he may be compelled to do so as he has no option to give a duplicate copy of the said instrument. As per Section 52 of the Act, the endorser of a negotiable instrument may, by express words in the endorsement, exclude his own liability thereon, or make such liability or the right of the endorsee to receive the amount due thereon depend upon the happening of a specified event, although such event may never happen. This is called conditional endorsement, where an endorser so excludes his liability and afterwards becomes the holder of the instrument, all intermediate endorsers are liable to him. Example 1. The endorser of a negotiable instrument signs his name adding the words, "without resources." Upon this endorsement, he incurs no liability. Example 2. X is both holder as well payee of a negotiable instrument. Excluding personal liability, by an endorsement, without recourse, he transfers the instrument to B, and B further endorses it to C, who endorses it to A. A is not only reinstated in his former rights, but has the rights of an endorsee against B and C. As clear from the above examples, we can say that an endorser can exclude or limit his liability in the following ways. A. By excluding his liability by making a sans recourse endorsement. This can be done by adding the words sans recourse, without recourse, to the endorsement. For example, the endorsement can be in the form pay A or order without recourse to me, or pay A or order sans recourse, or pay A or order at his own risk. In the instant case, if the instrument is dishonored, the subsequent holder or the endorsee cannot look to the endorser for the payment of the same. where an endorser excludes or limits his liability in this manner and afterwards becomes the holder of the same instrument, all intermediate endorsers continue to be liable to him. B. Sans phrase endorsement. It may be understood that where the endorser does not want that the endorsee or any other holder to incur any expense on his account, it is called a sans phrase endorsement. In a sans phrase endorsement, the endorsee or any other holder does not want to incur any expense on his account. This is called without expense endorsement also. C. By making his liability contingent upon an uncertain event, which may never happen, as when the uncertain future event is not possible, his liability is extinguished. But the endorsee can sue the prior parties before happening of the event. Example: the holder of a bill may endorse it pay a or order on the arrival of the ship Vikrant at Surat or pay a or order on his marriage with B. In all these cases, the liability of the holder as an endorser would arise upon the happening of the event specified. D. By making right of endorse to receive payment on event which may never happen. In this case, endorsee cannot sue prior parties before the happening of the specified event. E. Partial endorsement. In order to be called a proper and valid endorsement, the whole amount of the bill has to be endorsed. A part of the amount of an instrument cannot be endorsed. However, where a part of the amount has been paid or received by the holder, in such endorsement of the remaining unpaid amount can be made. Example: an instrument is of 5,000. However, if any party to the instrument endorsee it for 4,000 in favor of any party, such endorsement will not be valid. However, where 1,000 has been received against that instrument and the fact is recorded in the instrument, then the endorsement of balance 4,000 is perfectly valid. F. Facultative endorsement. In case of such an endorsement, the endorser abandons some rights or increases his liability as endorser E.G. pay a or order. Notice of dishonor waived. Material alteration. Any material alteration of a negotiable instrument renders the same void as against anyone who is a party thereto at the time of making such alteration and does not consent thereto, unless it was made in order to carry out the common intention of the original parties. Alteration by endorsee. And any such alteration, if made by an endorsee, discharges his endorser from all liability to him in respect of the consideration thereof. It may be noted that to get benefit of this section, the alteration must be intentional and not purely accidental. Secondly, the alteration must be material. In Lukaram Sethia v. Ivan E. John, 1977, SC defined the term material alteration as follows. A material alteration is one which varies the rights, liabilities, or legal position of the parties as ascertained by the deeds in its original state, or otherwise various legal effects of the instruments as originally expressed, or which may otherwise prejudice the party bound by the deed as originally executed. Some of the alterations which have been held to be material in various cases are as under. I. Alteration of an order check to a bearer check except by or with the consent of the drawer. 2. Alteration by tearing material part of the instrument. 3. Alteration by erasing account paying crossing. J. Ladies Beauty v. State Bank of India, AIR 1984 Good 33. 4. Alteration by affixing stamps without the promises knowledge to a note. Thoma v. Union Khan 1967 Kar LJ 80 N Govda, VB Govda 1968 1 MVRS LJ 591. V. Alteration of the date of payment. A. Subha Reddy v. Neelpa Reddy Ramana Reddy AIR 1966 AP to 67. 6. Alteration of the time of payment. Long v. More, 1790 1793 ESP 155. 7. Alteration of the place of payment. Tidmarsh v. Grover 1813-23 LJQB to 61. 8. Alteration of the sum payable. Schofield v. Earl of Londesborough 1896 AC 514. 9. Alteration by adding new party to the instrument. Garner v. Walsh 1855 5 ESB 83. Kiss Smiley alteration by tearing a material part of the instrument. 11. Alteration of the rate of interest. Seeth Tulsidas Lalchand v. Rajagopal 1967 to MLJ 66. From the above cases of alteration which have been treated material alteration, we can say that any alteration which changes the legal character of the instrument or alters the liabilities of the parties, whether change is prejudicial or beneficial, is a material alteration. Though we have discussed that material alteration discharges the parties to an instrument, but still there are some alterations which do not vitiate the instrument. These are as under dash. Alteration before the completion of the instrument. 2. Crossing of an open check or conversion of general crossing into a special crossing. 3. Making qualified acceptance. 4. Completion of inchoate instrument. Making a blank endorsement into full endorsement. 6. Conversion of a bearer check into an order check. 7. Alteration with the consent of the party liable on the instrument. 8. Alteration made for the purpose of correcting mistake. 9. Making a blank instrument into a full endorsement. Payment of instrument on which alteration is not apparent. So far, we have discussed that material alteration on an instrument discharges the parties to it. Still, there may be some alteration in an instrument which may not be apparent at the time of payment. As per Section 89(1), where a promissory note, bill of exchange, or check has been materially altered but does not appear to have been so altered, or where a check is presented for payment which does not at the time of presentation appear to be crossed or to have had a crossing which has been obliterated, payment thereof by a person or banker liable to pay and paying the same according to the apparent tenor thereof at the time of payment, and otherwise in due course, shall discharge such person or banker liable to pay and paying the same according to the apparent tenor thereof at the time of payment, and otherwise in due course, shall discharge such a person or banker from all liability thereon, and such payment shall not be questioned by reasons of the instrument having been altered, or the check crossed. 2. Where the check is an electronic image of a truncated check, any difference in apparent tenor of such electronic image and the truncated check shall be a material alteration, and it shall be the duty of the bank or the clearing house, as the case may be, to ensure the exactness of the apparent tenor of electronic image of the truncated check while truncating and transmitting the image. 3. Any bank or a clearing house which receives a transmitted electronic image of a truncated check shall verify from the party who transmitted the image to it that the image so transmitted to it and received by it is exactly the same. If a bill of exchange which has been negotiated is, at or after maturity, held by the acceptor in his own right, all rights of action thereon are extinguished. Section 90. 3.3 Acceptance, assignment, and negotiation. Acceptance. Only certain types of bills require acceptance. Essentials of a valid acceptance are: I. Must be written on the face of the bill. 2. The bill must be signed by drawee or his authorized agent. 3. The accepted bill is required to be delivered to the holder of the instrument. Meaning of acceptance: a bill is said to be accepted when the drawee, i.e., the person on whom the bill is drawn, after putting his signature on it, either delivers it or gives notice of such acceptance to the holder of the bill or to some person on his behalf. Acceptor, after the drawee has accepted the bill, he is known as the acceptor. It is only the bill of exchange, other than check, which requires acceptance. However, acceptance is not necessary to make a valid bill. If a bill is not accepted, it does not become invalid. It only becomes dishonored by non acceptance. Presentation for acceptance may be excused in the following circumstances: A. Where the drawee is dead or insolvent. B. Where the drawee is a fictitious person or one incapable of contracting. C. When the drawee cannot be found with reasonable efforts. D. When acceptance has been refused on some other grounds. Acceptance in case of bills in sets. Where a bill is drawn in sets, the acceptance is required to be put on one part only. Where the drawee signs his acceptance on two or more parts, he may become liable on each of them respectively. When presentation for acceptance is necessary, A. Where the bill is payable at a given time after acceptance or after sight. B. Where the bill expressly stipulates that it shall be presented for acceptance before presented for payment. C. Where the bill is made payable at a place other than the place of residence or business of the drawee. In no other case is presentation for acceptance necessary in order to render liable any party to the bill. Types of acceptance. Acceptance may be either general or qualified. General acceptance. An acceptance is said to be general when the drawee accepts the bill without qualification to the order of the drawer. If the acceptance is not absolute, the holder may treat the bill as dishonored by non-acceptance. Qualified acceptance. An acceptance is said to be qualified when the drawee accepts the bill subject to qualification. It may be noted that an acceptance will not be treated as a qualified acceptance unless the qualification is expressed on the bill in the clearest language. The qualification may relate to an event, amount, place, time, etc. Circumstances indicating qualified acceptance. According to Section 86, an acceptance is qualified under the following circumstances: A. Where it undertakes the payment on the happening of an event therein stated. B. Where it undertakes the payment of part only of the sum ordered to be paid. C. Where it undertakes payment at a specified place of his choice and not otherwise or elsewhere. D. Where it undertakes the payment at a time other than that at which under the order it would be legally due. E. Where it is not signed by all drawees who are not partners. Effect of qualified acceptance. A. The holder may treat the bill as dishonored due to non-acceptance and after giving due notice of dishonor, sue the drawer and prior endorsers. B. If he accepts a qualified acceptance, all prior parties whose consent is not obtained are discharged as against the holder and those deriving title from him. Examples of qualified acceptance. A. Accepted payable when in funds. B. Accepted payable on giving up bill of lading. C. Accepted payable when a cargo consigned to me is sold. D. A bill drawn for 1,000 accepted for 900 only. E. Accepted payable at Delhi only where no place of payment is specified in the order. F. Accepted payable at Delhi only where the place of payment specified in the order was Bombay. G. Accepted payable 4 months after date where the bill drawn as payable 3 months after date. H. Accepted by A, B and C where drawees were A, B, C, and D who not partners. I. Accepted payable on receiving income tax refund. J. A bill drawn for 1,000 but accepted to the extent considered reasonable and just by a common friend of both. Negotiation Chapter 4 of the Act deals with negotiation. Section 14 defines the term negotiation. When a promissory note, bill of exchange, or check is transferred to any person, so as to constitute that person the holder thereof, the instrument is said to be negotiated. In L. Purushottam v. L. Banke Lal, AIR 1935 All. 1041 it was held that handing over a negotiable instrument to an agent for safe custody is not negotiation. There must be a transfer by the holder to the transferee to make the latter a holder within the meaning of Section 8. Delivery Section 46 provides that the making, acceptance or endorsement of a promissory note, bill of exchange or check is completed by delivery. The delivery is of two types. One is actual delivery and the other is constructive delivery. As between parties standing in immediate relation, delivery to be effectual must be made by the party making, accepting or endorsing the instrument, or by a person authorized by him in that behalf. As between such parties and any holder of instrument other than a holder in due course, it may be shown that the instrument was delivered conditionally or for a special purpose only, and not for the purpose of transferring absolutely the property therein. A promissory note, bill of exchange, or check payable to bearer is negotiable by the delivery thereof. A promissory note, bill of exchange, or check payable to order is negotiable by the holder by endorsement and delivery thereof. In Bhagwati Prasad v. Pahil Sundari AIR 1969 Pat to 15 it was held where property in a promissory note is transferred by partition, the transferee is entitled to maintain his suit on it. His rights cannot be defeated on the ground of non-endorsement. In Vaddi Venkatasmi v. M.H. Bigam, AIR 1956 AP 9, it was held that in addition to the mode of transfer of a promissory note indicated in Section 46 here are two other modes of its transfer. Times by operation of law and times transfer, as a chosen action contemplated by Section 130 of the Transfer of Property Act. The only difference between the two modes is that, while transfer by negotiation clothes the transferee with certain rights, assignment, as a chosen action under Section 130 limits such rights, as the transferor had in the document i.e., the assignee takes only subject to equities in favor of the maker, an assignee of a promissory note otherwise than by endorsement such as transfer by means of writing under Section 130 of the Transfer of Property Act, can sue on the promissory note. Negotiation is of two types. One is negotiation by delivery, and the other is negotiation by endorsement. Negotiation by delivery. Section 47 provides that subject to the provisions of Section 58 a promissory note, bill of exchange or check payable to bearer is negotiable by delivery thereof. There is an exception to this. A promissory note, bill of exchange or check delivered on condition that it is not to take effect except in certain event is not negotiable, except in the hands of a holder for value without notice to the condition, unless such event happens. Example 1a. The holder of a negotiable instrument payable to bearer delivers it to B.S. agent to keep for B. The instrument has been negotiated. 2a. The holder of a negotiable instrument payable to bearer, which is in the hands of A's banker, who is at the time the bank of B, directs the banker to transfer the instrument to B's credit in the banker's account with B. The banker does so, and accordingly now possesses the instrument as B's agent. The instrument has been negotiated, and B has becomes the holder of it. Negotiation by endorsement. Section 48 provides that subject to the provisions of Section 58, a promissory note, a bill of exchange or check payable to order is negotiable by the holder by endorsement and delivery thereof. In Chetram v. Mohanlal, AIR 1957 NAG 65, it was held that where a promissory note payable to a particular person does not contain any words prohibiting transfers or indicating that it was not transferable, it would be a negotiable instrument payable to order. It would be negotiable by the holder by endorsement and delivery, with the necessary intention to constitute the person in whose favor the endorsement is made as the holder thereof. There must be intention of the endorser to constitute the endorsee as a holder of the note accompanied by delivery. Unless this is proved, negotiation is not complete. Conversion of endorsement in into endorsement in. Section 49 provides that the holder of a negotiable instrument indus in blank may, without signing his own name, by writing above the indus signature a director to pay to any other person as endorsee, convert the endorsement in blank into an endorsement in full, and the holder does not thereby incur the responsibility of an endorse. Effect of endorsement. Section 50 provides that the endorsement of a negotiable instrument followed by delivery transfer to the endorsee the property therein with the right of further negotiation, but the endorsement may, by express words, restrict or exclude such right, or may merely constitute the endorsee an agent to endorse the instrument, or to receive its contents for the endorser, or for some other specified person. Example, B signs the following endorsements on different negotiable instruments payable to bearer. A. Pay the contents to C only. B. Pay C for my use. C. Pay C for order for the account of B. D. The within must be credited to C. These endorsements exclude the right of further negotiation by C. E. Pay C. F. Pay C value in account with the Oriental Bank. G. Pay the contents to C, being part of the consideration in a certain deed of assignment executed by C to the indusser. And others, these endorsements do not exclude the right of further negotiation by C. In Vasudev v. National Savings Bank, IR 1953 Bond 209, it was held that Section 50 deals with what are known as restrictive endorsements, which in express words restrict or exclude the rights of endorsees. It does not apply to cases where the endorsee wishes to satisfy the court by oral evidence that he was endorsee for a particular purpose only. Who may negotiate? Section 51 provides that every sole maker, drawer, pay or endorsee, or all of several joint makers, drawers, payees or endorsees of a negotiable instrument may, if the negotiability of such instrument has not been restricted or excluded as mentioned in Section 50, endorse and negotiate the same. Nothing in this section enables a maker or drawer to endorse or negotiate an instrument unless he is in lawful possession or is holder thereof, or enables a payee or endorsee to endorse or negotiate an instrument unless he is holder thereof. Example, a bill is drawn payable to A or order. A endorses it to B, the endorsement not containing the words or order or any equivalent words. B may negotiate the instrument. Indusser who excludes his own liability. Section 52 provides that the indusser of a negotiable instrument may, by express words in the endorsement, exclude his own liability thereon, or make such liability or the right of the endorsee to receive the amount due thereon depend upon the happening of a specified event, although such event may never happen. Where an endusser so excludes his liability, and after becomes the holder of the instrument, all intermediate indussers are liable to him. Holder deriving title from holder in due course. Section 53 provides that a holder of a negotiable instrument who derives title from a holder in due course has the rights thereon of that holder in due course. Instrument indust in blank. Section 54 provides that subject to the provisions contained as to cross checks, a negotiable instrument indust in blank is payable to the bearer thereof even although originally payable to order. Claim on the conversion of endorsement of blank into endorsement in full. Section 55 provides that if a negotiable instrument, after having been indust in blank, is indust in full, the amount of it cannot be claimed from the indusser in full, except by the person to whom it has been indust in full, or by one who derives the title through such person. Endorsement for part of sum due. Section 56 provides that no writing on a negotiable instrument is valid for the purpose of negotiation if such writing purports to transfer only a part of the amount appearing to be due on the instrument where such amount has been partly paid. A note to that effect may be indust on the instrument, which may then be negotiated for the balance. Instrument obtained by unlawful means. Section 57 provides that when a negotiable instrument has been lost or has been obtained from any maker, acceptor or holder by means of an offense or fraud or for an unlawful consideration, no possessor or endorsee who claims through the person who found or so obtained the instrument is entitled to receive the amount due thereon from such maker, acceptor or holder, or from any party prior to such holder, unless such possessor or endorsee is, or some person through whom he claims was, a holder thereof in due course. Instrument acquired after dishonor. Section 59 provides that the holder of a negotiable instrument, who has acquired it after dishonor, whether by non-acceptance or non-payment, with notice thereof, or after maturity, has only, as against the other parties, the rights thereon of his transferor. Accommodation bill. Any person who in good faith and for consideration becomes the holder, after maturity, of a promissory note or a bill of exchange made, drawn or accepted without consideration, for the purpose of enabling some party thereto to raise money thereon, may recover the amount or bill from any party. Example, the acceptor of a bill of exchange, when he accepted it, deposited with the drawer certain goods as a collateral security for the payment of the bill, with power to the drawer to sell the goods and apply the proceeds in discharge of the bill. But if it were not paid at maturity, the bill not having been paid at maturity, the drawer sold the goods and retained the proceeds, but indust the bill to A. A's title is subject to the same objection as the drawer's bill. Instrument negotiable till payment. Section 60 provides that a negotiable instrument may be negotiated except by the maker, drawee, or acceptor after maturity, until payment or satisfaction by the maker, drawee or acceptor at or after maturity, but not after such payment or satisfaction. Presentment. Chapter 5 of the Act provides the procedure of presentment of negotiable instruments. Times. Section 61. Presentment for acceptance. Times. Section 62. Presentment of promissory note at sight. Times. Section 63. Drawee's time for deliberation. Times. Section 64. Presentment for payment. Times. Section 65. Hours for presentment. Times. Section 66. Presentment for payment of instrument payable after the date or sight. Times. Section 67. Present for payment of instrument payable by installments. Times. Section 68. Presentment for payment of instrument payable at specified place and not elsewhere. Times. Section 69. Instrument payable at specified place. Times. Section 70. Presentment where no exclusive place specified. Times. Section 71. Presentment when maker, etc., has no known place of business or residence. Times Section 72. Presentment of check to charge drawer. Times Section 73. Presentment of check to charge any other person. Times Section 74. Presentment of instrument payable on demand. Times Section 75. Presentment by or to agent, representative or deceased or assignee of insolvent. In Jagjeevan Mavji v. Rancho Das AIR 1954 SC 553, it was held by the Supreme Court that a bill payable after sight has two distinct stages. Firstly, when it is presented for acceptance, and later when it is presented for payment. Section 61 deals with the former and Section 64 deals with the later. Presentment for acceptance must always, and in every case, precede presentment for payment. But when the bill is payable on demand, both stages synchronize, there would be only one presentment, both for acceptance and for payment. When the bill is paid, it involves acceptance, but when not paid, it is really dishonored for non-acceptance. But whether the bill is payable after sight, or at sight, or on demand, acceptance by the drawee is necessary before he can fixed with liability on it. It is acceptance that establishes privity on the instrument between the payee and the drawee. In Banaras Bank Limited v. Normusti Pestanji, AIR 1930 All. 648, it was held that Section 64 should be given its plain meaning. The exception to it must be read as more or less an independent rule of law. Non-presentment of hundies for payment does not exempt the acceptor from his liability. It exempts only other parties to the hundies. In Nanumal v. Shibba Mal AIR 1939 La. 18, it was held that where the place of payment is not indicated by the maker in the instrument, the note or bill has to be presented at the place of business, if any, or at the usual residence of the maker, drawee or acceptor. In Jayaram v. Sivram AIR 1963 Mat to 94, it was held that the term specified place in Section 69 must have been intended to refer to a place indicated with sufficient precision to enable the person who wants to charge the maker with liability to resort to him readily. A promissory note which refers to a large city like Madras as the place for presentment does not fall under Section 69 and does not require presentment. In Gopikishan v. Jetmal Air 1935 Nag.144, it was held that in the absence of any indication in the instrument itself of the place of payment, presentment must be at the place of business of the acceptor or maker or the place where his home or residence. Presentment when not necessary. Section 76 provides that no presentment for payment is necessary in any one of the following cases. Times if the maker, drawee or acceptor intentionally prevents the presentment of the instrument, or times if the instrument is being payable at his place of business, he closes such place on a business day during the usual business hours, or times if the instrument being payable at some other specified place, neither he nor any person authorized to pay it attends at such place during the usual business hours, or times if the instrument not being payable at any specified place, he cannot after due such be found. Times as against any party sought to be charged therewith, if he has engaged to pay notwithstanding non-presentment. Times as against any party if, after maturity, with knowledge that the instrument has not been presented, he makes a part payment on account of the amount due on the instrument or promises to pay the amount due thereon in whole or in part, or otherwise waives his right to take advantage of any default in presentment for the payment. 88. Payment and interest. Chapter 6 deals with the payment of interest. Section 78 provides that the payment should be made to the holder or his accredited agent. Section 79 provides that interest is payable on the amount which has been paid after the due date. The interest is payable from the date of due to the date of realization. Section 80 provides that when no interest rate has been specified in the instrument, then the interest shall be calculated at the rate of 18% per annum from the date of due to the date of realization of the amount. Section 80 provides that any person liable to pay and called upon by the holder to pay the amount due on a negotiable instrument is before payment entitled to have it shown and is on payment entitled to have it delivered up to him, or if the instrument is lost or cannot be produced to be indemnified against any further claim thereon against him. Assignment of negotiable instruments. Assignment takes place where the holder of an instrument transfers it to another so as to confer a right on the transferee to receive the payment of the instrument. All negotiable instruments are chosen action and as such are transferable by assignment without endorsement under sections 130 to 132 of the Transfer of Property Act. Assignment of a negotiable instrument is effected by writing without endorsement. The main feature of assignment is that the assignee obtains the right of the assigner. Therefore, if the assigner's title is defective, assignee's title will also be defective. Difference between negotiation and assignment. Negotiation assignment. Consideration is presumed until contrary is proved. Consideration must be proved. A transferee is a holder in due course, he takes the instrument free from any defects. Assignee's title is always subject to defenses and equities between the original debtor and assigner. Notice of transfer is not necessary. Notice of assignment must be given. Negotiation is effected by delivery in case of instruments payable to bearer and by delivery and endorsement in case of instrument payable to order. Assignment is effected only by writing. Transferee can sue the third party in his own name. Assignee cannot do so. There are a number of presumptions in favor of holder in due courses. There are no such presumptions. Discharge from liability. Chapter 7 deals with the discharge from liability on negotiable instruments. Section 82 provides the methods of discharge from liability. Times by cancellation, times by release, and times by payment. Section 83 provides that if the holder allows the drawee more than 48 hours, exclusive of public holidays, to consider whether he will accept the same, all previous parties not consenting to such allowance and thereby discharged them from liability to such holder. Delay in presentation of check. Section 84 provides that where a check is not presented for payment within a reasonable time, and the drawer at the time when presentment ought to have been made, as between himself and the banker, to have the check paid, and suffers actual damage through the delay, he discharged to the extent of such damage, that is to say, to the extent to which such drawer is a creditor of the banker to a larger amount that he would have been if such check had been paid. In Abdul Majid v. Ganesh Das Kaluram, AIR 1954 ORI 124, it was held that a drawer of a check who wants to take advantage of Section 84 must prove to facts times he had sufficient money in deposit in the bank in his account to honor the check, and times he had suffered actual damage on account of non-presentment of the check within a reasonable time. Check payable to order. Section 85 providesth where a check payable to order purports to be endorsed by or on behalf of the pay, the drawing is discharged by the payment in due course. Where a check is originally expressed to be payable to bearer, the drawing is discharged by payment in due course to the bearer thereof, notwithstanding any endorsement whether in full or in blank appearing thereon, and notwithstanding that any such endorsement purports to restrict or exclude further negotiation. 3.4 Rights and liabilities of parties. Parties to notes, bills, and checks. Chapter 3 of the Act deals with the parties to notes, bills, and checks. Capacity. Section 26 provides that every person capable of contracting may bind himself and be bound by the making, drawing, acceptance, endorsement, delivery, and negotiation of a promissory note, bill of exchange, or check. A minor may draw, endorse, deliver, and negotiate such instruments so as to bind all parties except himself. Nothing herein contained shall be deemed to empower a corporation to make, endorse, or accept such instruments except in cases in which, under the law for the time being in force, they are so empowered. In Sulochana v. Nadayan Bank Limited, AIR 1975 Mat 70, DB, it was held that when a minor being along with one other executed a promissory note, held, though no liability could be enforced against the minor executants, the other executants, also a party to the document, could not escape his liability. In Orillo Industries Limited v. Bombay Mercantile Bank Limited, AIR 1961 SC 993, it was held that Section 26 does not purpose to make any provision of substantive or procedural law. The latter part of the section merely brings out that a company cannot claim authority to issue a check under its first part. The law in regard to the company's power to issue negotiable instruments has to be found in the relevant provisions of the Companies Act itself. Agency. Section 27 provides that every person capable of binding himself or being bound may so bind himself or be bound by a duly authorized agent acting in his name. A general authority to transact business and to receive and discharge debt does not confer upon an agent the power of accepting or endorsing bills of exchange so as to bind his principal. An authority to draw bills of exchange does not itself import an authority to endorse. In M. Rajagopal v. K.S. Imam Ali, AIR 1981 36, DB, it was held that in case of conflict between Sections 19 and 22 of the Partnership Act on the one hand and Sections 26, 27, and 28 of the Negotiable Instruments Act on the other, the latter act should prevail. A claim against a firm based on a written contract by one partner in the course of business and with authority to act is binding on the firm. But when such claim is made on a promissory note or bill of exchange, the court has to be satisfied that the negotiable instrument disclosed the liability of the firm clearly. Liability of agent. Section 28 of the Act provides that an agent who signs his name to a promissory note, bill of exchange, or check without indicating thereon that he signs as agent, or that he does not intend thereby to incur personal responsibility, is liable personally on the instrument, except to those who induced him to sign upon the belief that the principal only would be held liable. This section carries an exception to the general law of contract, that the principal, though not disclosed on the instrument, may be proceeded against if it is discovered later on that the agent had acted on his behalf, as held in Ramanathan v. Baldev Singh AIR 1933 Rank. 111. Liability of the representative. Section 29 provides that a legal representative of a deceased person who signs his name to a promissory note, bill of exchange, or a check is liable personally thereon unless he expressly limits his liability to the extent of the assets received by him as such. Liability of drawer. Section 30 provides that the drawer of a bill of exchange or check is bound, in case of dishonor by the drawee or acceptor thereof, to compensate the holder, provided due notice of dishonor has been given to or received by the drawer as herein provided. In Union Bank of India v. Swastika Motors, AIR 1983 Dale 420 it was held that a drawee having dishonored the Hundis, their drawer would be liable to the pay provided he had due notice of dishonor, even if the documents of title accompanying the Hundis had been delivered to the drawee without valid acceptance. In Silchar Bank v. Pioneer Bank, AIR 1951 Assam 127, it was held that if the drawee bank dishonors the check after the drawer had stopped payment, the question of notice of dishonor does not arise. The drawer is liable to compensate the holder. Liability of the drawee of check. Section 31 provides that the drawee of a check having sufficient funds of the drawer in his hands property applicable to the payment of such check must pay the check when duly required so to do, and, in default of such payment, must compensate the drawer for any loss or damage caused by such default. Liability of maker of note and acceptor of bill. Section 32 provides that in the absence of contract, to the contrary, the maker of promissory note and the acceptor before maturity of a bill of exchange are bound to pay the amount thereof at maturity according to the apparent tenor of the note or acceptance respectively, and the acceptor of a bill of exchange at or after maturity is bound to pay the amount thereof to the holder of the demand. In default of such payment, such maker or acceptor is bound to compensate any party to the note or bill for any loss or damage sustained by him and caused by such default. In Jagjeevan Mavji v. Ranchodas, AIR 1954 SC 554, the Supreme Court held that the drawee of a negotiable instrument is not liable to the pay unless the drawee has accepted it. Under Section 30 to the liability of the drawee arises only when he accepts the bill. There is no provision in the Act that the drawee is as such liable on the instrument, except under Section 31 when the drawee has sufficient funds of the customer in his hands, and even then, the liability is only towards the drawer, not the pay. In M. Ramnaran Private Limited v. State Trading Corporation of India Limited, AIR 1988 Bomb 45, DB, it was held that where the pay was the holder of bills but not willing to part with them unless the entire amount covered by the bills had been paid to him, the drawer may sue the acceptor for compensation but only after payment to the pay and his endorsement on the bills in favor of the drawer. Only drawee can be accepted except in need or for honor. Section 33 provides that no person except the drawee of the bill of exchange or all or some of several drawees or a person named therein as a drawee in case of need or an acceptor for honor can bind him by an acceptance. In Manikchand v. Chartered Bank, AIR 1961 calories. 653 DB, the High Court narrated the scope of Section 33. Section 33 must not be misread as preventing the drawee from accepting through an agent. Under Section 26 and 27, the drawee can accept a bill through his agent. Acceptance by several drawees not partners. Section 34 provides that where there are several drawees of a bill of exchange who are not partners, each of them can accept it for himself, but none of them can accept it for another without his authority. Liability of indusser. Section 35 provides that in the absence of contract to the contrary, whoever endorses and delivers a negotiable instrument before maturity, without, in such endorsement, expressly excluding or making conditional his own liability, is bound thereby to every subsequent holder, in case of dishonor by the drawer, acceptor or maker, to compensate such holder for any loss or damage caused to him by such dishonor, provided due notice of dishonor has been given to, or received by, such indusser as hereinafter provided. Liability of prior parties to holder in due course. Section 36 provides every prior party to a negotiable instrument is liable thereon to holder in due course until the instrument is duly satisfied. Maker, drawer and acceptor principles. Section 37 provides that the maker of a promissory note or a check, the drawer of a bill of exchange until acceptance, and the acceptor are, in the absence of a contract, to the contrary, respectively liable thereon as principal debtors, and the other parties thereto are liable thereon as sureties for the maker, drawer or acceptor as the case may be. Prior party a principal in respect of each subsequent party. Section 38 provides that as between the parties so liable as sureties, each prior party is, in the absence of a contract, to the contrary, also liable thereon as a principal debtor in respect of each subsequent party. Example: A draws a bill payable to his own order on B, who accepts. A afterwards endorses the bill to C, C to D, and D to E. As between E and B, B is the principal debtors, and A, C, and D are his sureties. As between E and A is the principal debtors and C and D are his sureties. As between E and C the principal debtor and D is his surety. Suretyship. Section 39 provides that when the holder of an accepted bill of exchange enters into any contract with the acceptor which, under sections 134 or 135 of the Contract Act, would discharge the other parties, the holder may expressly reserve his right to charge the other parties, and in such case they are not discharged. Discharger of indusser's liability. Section 40 provides that where the holder of a negotiable instrument, without the consent of the indusser, destroys or impairs the indusser's remedy against a prior party, the indusser is discharged from liability to the holder to the same extent as if the instrument had been paid at maturity. Example: as the holder of a bill of exchange made payable to the order of B, which contains the following endorsements in blank. Times first endorsement B. Times second endorsement Peter Williams. Times third endorsement Wright and Co. Times fourth endorsement John Rosario. This bill A puts in suit against John Rosario and strikes without John Rosario's consent the endorsements by Peter Williams and Wright and Co. A is not entitled to recover anything from Rosario. Acceptor bound, although endorsement forged. Section 41 provides that an acceptor of a bill of exchange already endorsed is not relieved from liability by reason that such endorsement is forged, if he knew or had reason to believe the endorsement to be forged when he accepted the bill. Acceptance of bill drawn in fictitious name. Section 42 provide that an acceptor of a bill of exchange drawn in a fictitious name and payable to the drawer's order is not, by reason that such name is fictitious, relieved from liability to any holder in due course claiming under an endorsement by the same hand as the drawer's signature, and purporting to be made by the drawer. Negotiable instrument made without consideration. Section 43 provides that a negotiable instrument made, drawn, accepted, endorsed or transferred without consideration, or for a consideration which fails, creates no obligation of payment between the parties to the transaction. But if such party has transferred the instrument, with or without endorsement, to a holder for consideration, such holder, and every subsequent holder deriving title from him may recover the amount due on such instrument from the transferor for consideration or any prior party thereto. Explanation 1 to this section provides that no party for whose accommodation a negotiable instrument has been made, drawn, accepted, or endorsed can, if he has paid the amount thereof, recover thereon such amount from any person who became a party to such instrument for his accommodation. Explanation 2 to this section provides that no party to the instrument who has induced any other party to make, draw, accept, endorse or transfer the same to him for a consideration which he failed to pay or perform in full shall recover thereon an amount exceeding the value of the consideration, if any, which he has actually paid or performed. In Ram Narayan v. Ramjeevan AIR 1937 Nag. 267, it was held that Section 43 must be read subject to Section 59 in all cases in which the latter section applies, the holder, as against other parties, would have only the rights thereon of his transferor. Partial absence or failure of money consideration. Section 44 provides that when the consideration for which a person signed a promissory note, bill of exchange, or check consisted or money, and was originally absent in part of has subsequently failed in part, the sum which is a holder standing in immediate relation with such signer is entitled to receive from his is proportionately reduced. Explanation to this section provides that the drawer of a bill of exchange stands in immediate relation with the acceptor. The maker of a promissory note, bill of exchange, or check stands in immediate relation with the payee, and the endorser with the endorsee. Other signers may by agreement stand in immediate relation with the holder. Example: A draws a bill on 500 payable to the order of A. B accepts the bill, but subsequently dishonors it by non-payment. A sues B on the bill. B proves that it was accepted for value as to 400 and as accommodation to the plaintiff as to the residue. A can only recover 400 dash. In Muttalayarkadu v. State of Andhra Pradesh, 1955, and WR 870, it was held that where a promissory note has been endorsed to a third person, Section 44 cannot be applied so as to prejudice his rights. Where the maker of the promissory note stands in immediate relation to the payee, Section 44 would entitle the debtor to relief. In Tirupagri Tayaramma v. Sri Ramanjanaya Mercantile Co. Illuru, AIR 1977 AP 205, it was held that Section 44 would not apply when consideration for the promissory note was a set of obligations, not merely of money. Partial failure of consideration not consisting of money. Section 45 provides that where a part of the consideration for which a person signed a promissory note, bill of exchange, or a check, though not consisting of money, is ascertainable in money without collateral enquiry, and there has been a failure of that part, the sum which a holder standing in immediate relation with such signer is entitled to receive from him is proportionately reduced. Holder's right to duplicate of lost bill. Section 45 provides that where a bill of exchange has been lost before it is overdue, the person who was the holder of it may apply to the drawer to give him another bill of the same tenor, giving security to the drawer, if required, to indemnify him against all persons whatever in case the bill alleged to have been lost shall be found again. If the drawer on request refuses to give such duplicate bill, he may be compelled to do so. 4.5 Dishonor of negotiable instrument. Notice of dishonor. Chapter 8 deals with the notice of dishonor. When dishonored, the dishonor may be due to the following reasons: times non-acceptance and times by non-payment. Section 91 provides that a bill of exchange is said to be dishonored by non-acceptance when the drawee, or one of several drawees, not being partners, makes default in acceptance upon being duly required to accept the bill, or where presentment is excused and the bill is not accepted. When the drawee is incompetent to contract, or the acceptance is qualified, the bill may be treated as dishonored. Section 92 provides that an instrument is said to be dishonored by non-payment when the maker of the note, acceptor of the bill, or drawee of the check makes default in payment upon being duly required to pay the same. Notice. Section 93 provides that when an instrument is dishonored, holder must give notification instrument has been dishonored. In Union Bank v. Dina Nath, AIR 1953 All. 637, it was held that this section was intended to confine the holder's right of enforcing the liability to only those who are otherwise liable under the law and to whom notice has been given. It was not intended to enlarge the holder's rights so as to enable him to claim damages from persons against whom he has no remedy under the Act. Mode of giving notice. Section 94 provides that the notice may be in writing or oral. If it is in written form, it must be sent by post, and may be in any form, but it must inform the party to whom it is given either in express term or by reasonable intendment that the instrument has been dishonored, and he will be held liable thereon. It must be given within a reasonable time after dishonor, at the place of business, or at the residence of the party for whom it is intended. Section 95 provides that any party receiving notice of dishonor must, in order to render any prior party liable to himself, give notice of dishonor to such party within a reasonable time, unless such party otherwise receives due notice. Section 96 provides that when the instrument is deposited with an agent for presentment, the agent is to issue notice to his principal, who is entitled to a further like period to give notice of dishonor. Section 97 provides that when the party, to whom a notice of dishonor is dispatched, is dead, but the party is not aware of the death, the notice is sufficient. Notice, when not necessary. Section 98 provides that in the following circumstances, there is no requirement to issue notice: times when it is dispensed with by the party entitled thereto, times in order to charge the drawer, when he has countermanded payment, times when the party charged could not suffer damage for want of notice, times when the party entitled to notice cannot after due search be found, or the party bound to give notice is, for any other reason, unable without any fault of his own to give it, times to charge the drawers, when the acceptor is also a drawer, times in the case of a promissory note which is not negotiable, times when the party entitled to notice, knowing the facts, promises unconditionally to pay the amount due on the instrument. Noting and Protest. Chapter 9 deals with the procedure of noting and protest. Noting. Section 99 provides that when an instrument is dishonored for any reason, the holder may cause the dishonor to be noted by a notary public upon the instrument, or upon a paper attached thereto, or partly upon each. The noting must be made within a reasonable time after dishonor. The noting must specify the date of dishonor, the reason assigned for such dishonor, or if the instrument has not been expressly dishonored, the reason the holder treats it as dishonored, and the notary's charges. Protest. Section 100 provides that when an instrument is dishonored, the holder may cause such dishonor to be noted and certified by a notary public. Such certificate is called a protest. When the acceptor of an instrument becomes insolvent or his credit has been publicly impeached before maturity of bill, the holder may, within a reasonable time, cause a notary public to demand better security of the acceptor and on its being refused may, within a reasonable time, cause such facts to be noted and certified. Such certificate is called a protest for better security. Contents of the protest. Section 101 provides that a protest must contain times either the instrument itself or a literal transcript of the instrument and of everything written or printed thereupon. Times the name of the person for whom and against whom the instrument has been protested, times a statement that payment or acceptance or better security, as the case may be, has been demanded of such person by the notary public, or that he could not be found, times when the note or bill has been dishonored, the place and time of dishonor, and when better security has been refused, the place and time of refusal. Times the subscription of the notary public making the protest, times in the event of an acceptance for honor or of a payment for honor, the name of the person by whom, of the person for whom, and the manner in which such acceptance or payment was offered and effected. Notice of Protest Section 102 provides that notice of protest must be given instead of notice of dishonor in the same manner and subject to the same conditions, but the notice may be given by the notary public who makes the protest. Special Rules of Evidence. Chapter 13 deals with this subject. Section 118. What are the presumptions that can be made as to negotiable instruments? Until the contrary is proved, the following presumptions shall be made: times of consideration, times as to date, times as to time of acceptance, times as to time of transfer, times as to order of endorsement, times as to stamp, times that holder is a holder in due course. It can be presumed that times every negotiable instrument was made or drawn for consideration, and that every such instrument, when it has been accepted, endorsed, negotiated or transferred, was accepted, endorsed, negotiated or transferred for consideration. Times every negotiable instrument bearing a date was made or drawn on such date. Times every accepted bill of exchange was accepted within a reasonable time after its date and before its maturity. Times every transfer of a negotiable instrument was made before its maturity. Times the endorsement appearing upon a negotiable instrument were made in the order in which they appear thereupon. Times a promissory note, bill of exchange of check was duly stamped. Times the holder of a negotiable instrument is a holder in due course. Owners of holder in due course where the instrument has been obtained from its lawful owner or from any person in lawful custody thereof by means of an offense or fraud, or has been obtained from the maker or acceptor thereof by means of an offense or fraud, or for unlawful consideration, the burden of proving that the holder is a holder in due course lies upon them. Presumption on proof of protest. Section 119 provides that in a suit upon an instrument which has been dishonored, the court shall, on proof of the protest, presume the fact of dishonor, unless and until such fact is disproved. Estoppel. Sections 120 to 122 deals with the following types of estoppels. Times estoppel against denying original validity of instrument. Times estoppel against denying capacity of pay to endorse. Times estoppel against denying signature or capacity of prior party. Section 120 provides that no maker of a promissory note, and no drawer of a bill of exchange or check, and no acceptor of a bill of exchange for the honor of the drawer shall, in a suit thereon by a holder in due course, be permitted to deny the validity of the instrument as originally made or drawn. Section 121 provides that no maker of a promissory note and no acceptor of a bill of exchange payable to order shall, in a suit thereon by a holder in due course, be permitted to deny the pay's capacity, at the date of the note or bill, to endorse the same. Section 122 provides that no indusser of a negotiable instrument shall, in a suit thereon by a subsequent holder, be permitted to deny the signature or capacity to contract of any prior party to the endorsement. International Law. Chapter 16 deals with the negotiable instrument in international law. Section 134 provides that in the absence of a contract, to the contrary, the liability of the maker or drawer of a foreign promissory note, bill of exchange, or check is regulated by the law of the place where he made the instrument, and the respective liabilities of the acceptor and endusser by the law of the place where the instrument is made payable. Example: a bill of exchange was drawn by A in California, where the rate of interest is 25% accepted by B, payable in Washington where the rate of interest is 6%. The bill is endorsed in India and is dishonored. An action on the bill is brought against B in India. He is liable to pay interest at the rate 6% only, but if A is charged as drawer, A is liable to pay interest at 25%. Section 135 provides that where a promissory note, bill of exchange, or a check is made payable in a different place from that in which it is made or endorsed, the law of the place where it is made payable determines what constitutes dishonor and what notice of dishonor is sufficient. Example: a bill of exchange is drawn and endorsed in India, but accepted payable in France, is dishonored. The endorsee causes it to be protested for such dishonor and given notice in accordance with the law of France, though not in accordance with the rules herein contained in respect of bill which are not foreign. The notice is sufficient. Section 136 provides that if an instrument is made, drawn, accepted, or endorsed outside India, but in accordance with the law of India, the circumstance that any agreement evidenced by such instrument is invalid according to the law of the country wherein it was entered into does not invalidate any subsequent acceptance or endorsement made thereon within India. Section 137 provides that the law of any foreign country regarding promissory notes, bill of exchange, and checks shall be presumed to be the same as that of India unless and until the contrary is proved. Penalties. Section 138 provides penalty for dishonor of check for insufficiency etc. of funds in the account. Where any check drawn by a person on an account maintained by him with a banker for payment of any money to another person from out of that account for the discharge, in whole or in part, of any debt or other liability, a legally enforceable debt or other liability, is returned by the bank unpaid. Times either because of the amount of money standing to the credit of that account is insufficient to honor the check, or times that it exceeds the amount arranged to be paid from that account by an agreement made with that bank. Such person shall be deemed to have committed an offense and shall, without prejudice to any other provision of this Act, be punished with imprisonment for a term which may be extended to 2 years or with fine which may extend to twice the amount of the check, or with both. The penal provision in this check shall not apply unless times the check has been presented to the bank within a period of 3 months, with effect from 1st April 2012, before that it is 6 months, from the date on which it is drawn or within the period of its validity, whichever is earlier. Times the pay or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days of the receipt of information by him from the bank regarding the return of the checks as unpaid, and times the drawer of such check fails to make the payment of the said amount of money to the pay or, as the case may be, to the holder in due course of the check within 15 days of the receipt of the said notice. Conditions precedent. In Kusum Ingots and Alloys Limited v. A&R Peterson Securities Limited, AIR 2000 SC 954, the Supreme Court held that the ingredients which are to be satisfied for making out a case under Section 138 of the Act are: times a person must have drawn a check on an account maintained by him in a bank for payment of a certain amount of money to another person from out of that account for discharge of any debt or other liability. Times that check has been presented to the bank within a period of 6 months, now 3 months, from the date on which it is drawn or within the period its validity whichever is earlier. Times that the check is returned by the bank unpaid, either because of the amount of money standing to the credit of the account is insufficient to honor the check or that it exceeds the amount arranged to be paid from that account by an agreement made with the bank. Times the payor holder in due course of the check makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 15 days, now 30 days, of the receipt of information by him from the bank regarding the return of the check as unpaid. Times the drawer of such check fails to make payment of the said amount of money to the pay or the holder in due course of the check within 15 days of the receipt of the said notice. Presumption in favor of holder. Section 139 provides that it shall be presumed, unless the contrary is proved, that the holder of a check received the check, of the nature referred to in Section 138, for the discharge, in whole or in part, of any debt or other liability. In B. Mohan Krishna v. Union of India, 1996 CRLJ 683, APDB, the Andhra Pradesh High Court Division Bench held that the presumption in Section 139 in favor of the holder of a check is not violative of Article 23 of the Constitution, which incorporates immunity against self-incrimination. Section 140 provides that it shall not be a defense in a prosecution for an offense under Section 138 that the drawer had no reason to believe when he issued the check that the check may be dishonored on presentment for the reasons stated in the section. Offenses by companies. Section 141 of the Act provides that a company and every person who was in charge of and responsible to the company for the conduct of the business of the company at the time of offense, the company and such person shall be liable to be proceeded against and punished accordingly. If such person proves that the offense was committed without his knowledge or that he has exercised such due diligence to prevent the commission of the offense, he shall not be punishable. Where a person is nominated as a director of the company by virtue of his holding any office or employment in the central government or state government or a financial corporation owned or controlled by the central government or the state government, as the case may be, he shall not be liable for prosecution under this chapter. If it is proved that the offense has been committed with the connivance or consent of, it is attributable to any neglect on the part of any director, manager, secretary or other officer of the company, such persons shall be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly. Cognizance of offense. Section 142 provides that no court shall take cognizance of any offense punishable under Section 138 except upon a complaint, in writing, made by the pay or the holder in due course of the check. Such complaint shall be made within 1 month of the date on which the cause of action arises. The cognizance of a complaint may be taken by the court after the prescribed period if the complainant satisfies the court that he has sufficient cause for not making a complaint within such period. No court inferior to that of a metropolitan magistrate or a judicial magistrate of the first class shall try any offence punishable under Section 138. The offence shall be inquired and tried only by a court within those local jurisdiction. Times if the check is delivered for collection through an account, the branch of the bank where the pay or holder in due course maintains the account is situated, or times if the check is presented for payment by the pay or holder in due course, otherwise through an account, the branch of the drawee bank where the drawer maintains the account is situated. Where a check is delivered for collection at any branch of the bank of the pay or holder in due course, then the check shall be deemed to have been delivered to the branch of the bank in which the pay or holder in due course maintains the account. Summary trial. Section 143 provides that all the offences under this chapter shall be tried by a judicial magistrate of the I class or by a metropolitan magistrate. The provisions of Section 262 to 265 of the Code of Criminal Procedure shall apply to such trials. In case of any conviction in a summary trial, it shall be lawful for the magistrate to pass a sentence of imprisonment for a term not exceeding 1 year and an amount of fine exceeding 5,000. When at the commencement of, or in the course of, a summary trial under this section, it appears to the magistrate that the nature of the case is such that a sentence of imprisonment for a term exceeding 1 year may have to be passed, or that it is, for any other reason, undesirable to try the case summarily, the magistrate shall, after hearing the parties, record an order to that effect, and thereafter recall any witness who may have been examined and proceed to hear or rehear the case in the manner provided by the Code of Criminal Procedure. The trial shall be continued from day to day until its conclusion, unless the court finds the adjournment of trial beyond the following day to be necessary for reasons to be recorded in writing. Every trial under this section shall be conducted as expeditiously as possible, and an endeavour shall be made to conclude the trial within 6 months from the date of filing of the complaint. The Act was amended in August 2018. Section 143A has been inserted, which empowers the court to direct the drawer to pay interim compensation up to 20% of the check value, which the drawer pleads no guilty. In case the drawer files an appeal, the appellate court may direct to the drawer to deposit 20% of the fine or compensation, in addition to what has been paid at trial stage. Service of summons. Section 144 provides that a magistrate issuing a summons to an accused or a witness may direct a copy of summons to be served at the place where such accused or witness ordinarily resides or carries on business or personally works for gain, by speed post or such courier services as are approved by a court of session. Where an acknowledgement purporting to be signed by the accused or the witness or an endorsement purported to be made by any person authorized by the Postal Department or the courier services that the accused or the witness refused to take delivery of summons has been received, the court issuing the summons may declare that the summons have been duly served. Evidence on affidavit. Section 145 provides that the evidence of the complainant may be given by him on affidavit and may, subject to all just exceptions, be read in evidence in any inquiry, trial or other proceeding under the Code of Criminal Procedure. The court may, if it thinks fit, and shall, on the application of the prosecution or the accused, summon and examine any person giving evidence on affidavit as to the facts contained therein. Banks slip, prima facie evidence. Section 146 provides that the court shall, in respect of every proceeding, on production of bank's slip or memo having thereon the official mark denoting that the check has been dishonored, presume the fact of dishonor of such check, unless and until such fact is disproved. Compounding. Section 147 of the Act provides that every offence punishable under this Act is compoundable. In M. Rangaswamy v. R. Kshettappa 2002 CRLJ 4792, Con, the High Court held that there is no prohibition in this Act against compounding of an offence punishable under Section 138. In the absence of any such prohibition, therefore, where the court finds that the parties have settled the matter, where the complainant being present before the court and submits before the court that the accused has paid the money covered by the check, it would be appropriate to allow the parties to compound, rather than negativing such a joint request made by the parties and proceeding to inflict the sentence on the accused. Particularly, when there is no prohibition against compounding, any rejection of request in that regard would not further the cause of the justice, and particularly where the commission of offence is not related to the society at large, but only against a particular person, viz., the complainant to whom certain sum is due under the check. Therefore, it would be legally permissible for the parties to compound the offence punishable under Section 138 of the Negotiable Instruments Act, 1881.